The FBI investigation involved interviewing Clinton and others. Agents summarized the interviews on FBI Form 302. No statements under oath, no transcripts, no recordings, no grand jury.
It is evident to me that what Mr. Comey should have done at the beginning of this investigation was impanel a grand jury. He did not do that.
I'm uncomfortable with the way the investigation was conducted. I think it should have used a grand jury, and people who were given immunity should have been taken before the grand jury then and said, you have immunity, you tell us everything under oath. That's the way you do it.
When you want to investigate crimes involving national security information, classified information, you don't do interviews. You issue subpoenas to witnesses, third parties for documents. You make people come into court and fight them in front of a federal judge.
And you grill them because they'll be protective of the people they like and they work with. So you have to grill them, but people will surprise you how sometimes they'll just spill the beans when they're under oath like that. So I think this was not the kind of an investigation that was likely to get to the bottom of it.
And there was no grand jury in this case. Not a single subpoena was issued. And he grants immunity to a number of people who never should have been granted immunity. They should have been thrown in front of a grand jury, forced to take the fifth, and then continue the investigation. Director Comey didn't do that.
Comey was asked why not by Congressman Tom Marino, a former prosecutor.
Let me ask you guys, we both impaneled many grand juries, investigative grand juries. Why not impanel an investigative grand jury, and then you have the ability to get warrants, subpoenas, get this information, subpoena witnesses before the grand jury under oath, and if they take the fifth, if it's not the target, if they take the fifth, they simply and say, I'm not going to talk to you, you can give them, whether it's use immunity, the AG can give them that, and you had that authority, and then transactional has to come from the judge. And if they refuse to testify then you can say, fine, we're going to take you before a judge, hold you in contempt, and then you're going to sit in jail until you answer our question. Why did you not decide to go to an investigative grand jury? It would have been cleaner, it would have been much simpler, and you would have had more authority to make these witnesses testify. Not the target, but the witness testify. That seems the way to go, Director. We've done it thousands of times. This just was too convoluted.
Yeah, again, I need to steer clear of talking about grand jury use in a particular matter. In general, in my experience, you can often do things faster with informal agreements.
Another issue involved Clinton associates Cheryl Mills and Heather Samuelson. Though witnesses in the case, they watched the FBI interview Clinton. Comey was grilled about that by Congressman John Ratcliffe, himself a former prosecutor.
I don't think that there's any reasonable prosecutor out there who would have allowed two immunized witnesses central to the prosecution to proving the case against her to sit in the room with the interview, the FBI interview of the subject of that investigation. And if I heard you earlier today, in your long career, I heard you say that you've never had that circumstance. Did I hear you correctly?
That's correct. But
okay, and I never have either, and I've never met a prosecutor that's ever had that.
I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met.
And it wouldn't have happened in the Clinton case if witnesses testified before a grand jury, as suggested by DeGeneva and others. The FBI's online PDF files reveal a staggering amount of missing evidence in the Clinton case. We're going to examine Part 1 and note the pages about the missing evidence. Congressman John Ratcliffe reviewed Part 1 during a hearing with then FBI Director James Comey.
So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it.
That information about the missing computer is on page 4. Check.
An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that.
The details about the missing laptop and thumb drive are on pages 1 and 17. Check.
2 BlackBerry devices provided the FBI didn't have SIM cards or SD data cards.
Those facts about the missing SIM and SD cards are on page 9. Check.
13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those.
The missing mobile devices are revealed on pages 9 and 30. Page 30 also reveals that 2 of Clinton's iPads are missing. Check.
Various server backups were deleted over time, so the FBI didn't examine that.
The backups are discussed on page 5. Check.
After the State Department and my colleague Mr. Gowdy here notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with Bleachbit, so the FBI didn't review that.
The Bleachbit facts are on page 18. Check. Bleachbit is a software program that permanently erases data.
After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with Bleachbit, so the FBI didn't review that.
The Bleachbit deletions are discussed on page 19. Check.
And also after the subpoena, backups of the Platte River server were manually deleted.
Those manual deletions are reported on page 19. Check.
Any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice.
We're in a fact-based world, so we make evaluations based on the evidence we're able to gather using the tools that we have. So it's hard for me to react to these things that you don't have.
To summarize, here's a list of the missing evidence. The original Apple server, a laptop, a thumb drive, SIM and SD cards, 13 mobile devices, 2 iPads, erased files on 2 laptops, and erased files on server backups. Congressman Ratcliffe says it's hard to ignore all that was missing.
And to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton.
On the very day that Congressman Ratcliffe itemized the missing evidence, another laptop is discovered, one unknown to the FBI. It will lead to the reopening of the Clinton investigation. More about that in our next report. News that 5 people received immunity in the Clinton case drew sharp criticism.
If someone in the Department of Justice had to decide to pass out these immunity agreements, and I see the get out of jail free cards, Brett, what I don't see is the jail. Usually you strike immunity agreements to further a prosecution. There is no prosecution. It's just 5 get out of jail free cards.
The most controversial immunity grants went to 2 of Clinton's attorneys. Cheryl Mills, her former chief of staff at the State Department, and Heather Samuelson.
When you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes.
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction.
Yeah, again, my recollection is no transactional immunity was given. As I understand it, this was a promise in writing from the Department of Justice. If you give us the laptops, we will not use anything on the laptops directly against you in a prosecution for that list of offenses.
While the hearing went on, the committee checked with the Justice Department.
Under the immunity agreement with one or more individuals, we'll use Cheryl Mills as clearly one of the individuals. She negotiated a very, very good deal from what we can discover. She did not just receive immunity related to the production of the drive, the computer, and the contents. Her immunity is against any and all taking, destruction, or even obstruction, the way we read it, of documents classified or unclassified.
Clinton attorneys Mills and Samuelson were granted immunity in return for turning over their laptops. Representative Gomert, a former judge, reminded Comey a grant of immunity wasn't necessary.
You had every authority to get a subpoena, and if you had brought a request for a search warrant, based on what we now know, I would have had no problem signing that warrant so you could go get it anywhere you want.
Congressman Trey Gowdy, a former prosecutor, agreed.
And if you think that there is evidence that is relevant to an investigation on a piece of physical property, you use a subpoena, a grand jury subpoena. You don't strike an immunity agreement with the computer, you go get the computer.
Doesn't it concern you as an investigator that your chiefs in the Justice Department decided to become an immunity-producing machine for many people who would have been very key witnesses should there have been a prosecution?
I don't think of it that way. Doesn't strike me there was a lot of immunity issued in this case.
You got really nothing substantial. It's as if you went into the investigation determined to give immunity to people instead of getting a warrant. You gave immunity to people that you would need to make a case if a case were going to be made.
Did the Justice Department want to make a case? Based on how it shaped the FBI's investigation with grants of immunity, it's easy to see how many conclude the government never intended to prosecute Clinton.